From the Palace at Uncle's Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for all your workers' compensation, employment, and labor law matters. My name is Steve Appel, and I'll be your host for the next hour with some talk, some news, and hopefully some answers about Work Comp Matters. Thanks for being part of the show, and if you can break away from your Work Comp Matters, feel free to give us a call and clue us in with your questions, comments, and or concerns. The phone number worldwide, 818-357-4120. You can send an email to wcexaminer@aol.com. You can even be old school. Send a fax, 818-475-1437. With me in studio, my right-hand man, Mike Zyma. My protege, attorney Robert Ozeron. Of Uncle's Studio engineer, Scott Walton. Special guest is Tom Manzo, and back at Work Comp Central, making sure the whole damn thing goes right, is Jake Harris. Well, good evening, everybody, and welcome to another edition of Work Comp Matters. Tonight's show is on PAGA, which is the Private Attorney General Act. We've got special guest his name is Tom Manzo, and he works for a company called Timely and started up nonprofit organization CABIA, which is the California Business and Industrial Alliance. Of course, as always, we're brought to you by A1 Law and Santa Monica Tickets. If you want the number one computer management system used by more workers' compensation attorneys than any other system in California, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day A1 Law. And, of course, if you want those hard-to-get, sold-out, even front row concert, sports, and theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. Before we get to Mr. Manzo, just want to give you the topics or the news for tonight. We're going to have the Supreme Court's decision on immigration and violent felons. We're going to be talking about Starbucks. We're going to be talking about a California Supreme Court case dealing with utilization review. I'm not sure if Robert knows this one. And then, of course, unfortunately, a wonderful woman, Barbara Bush, passed away. And last but not least, it appears that Donald Trump is going to go to Korea. But our number one news story of the day involves the following. Southwest pilot Tammy Jo Schultz saved almost 150 lives yesterday when the left engine on her Boeing 737 exploded at 30,000 feet in the air. Unfortunately, one passenger, Jennifer Reardon, died on the flight from New York to Dallas after shrapnel from the left engine blew out the window she was sitting next to. As one of the first female fighter pilots in the United States military, Tammy Jo Schultz is no stranger to displaying nerves of steel, and she safely landed the plane in a cool, calm, and deliberate emergency landing. That coolness was particularly notable in the following air traffic control recording.
Southwest 1380, New York.
Southwest 1380, go ahead.
Southwest 1380, understand. So there's you're a single engine for the fire?
Actually, we're no fire now, but we are single engine.
Okay, you are single engine now. Okay, so the next facility, I guess it's, can you maintain 11,000?
Yes, sir.
Okay, so 1380 instead of maintaining 11,000.
Okay, down to 11,000.
Southwest 1380, just so I can understand, you said that you are still single engine, and what else?
Okay, Southwest 1380, we're single engine. That's it.
Okay, single engine. Maintain 11,000. You need anything standing by on the truck?
Yes, if you would, have them roll the trucks. It's on the engine number 1, captain's side.
Okay, thank you. Southwest 1380, contact New York Center 135.45.
3545, good day.
And Schultz is married to a fellow Southwest pilot, Dean Schultz, whom she met in the Navy, and according to Reuters, she tried to attend an aviation career day in high school, but was told they did not accept girls. After college, she was turned down by the Air Force, but was accepted by the United States Navy for its aviation officer candidate school. Schultz was one of the first female FA-18 Hornet pilots and reached the rank of Navy Lieutenant Commander and became an instructor before leaving the Navy in 1993 to join Southwest Airlines. That is our newest American hero, Southwest pilot Tammy Jo Schultz. And as I said earlier, we're going to get to some more news, some more talk, and hopefully some answers. But want to say hello to our special guest. I have a colleague of mine who sends me business every so often, and he sent me this email, and he said, "Steve, is this a scam?" And I said, well, let's find out. So I looked up the email. There was a phone number there. I gave Mr. Manzo a call, and this was just last week. This is the first time I'm meeting the gentleman. So without further ado, ladies and gentlemen, Mr. Tom Manzo, thanks for joining us here at Uncle's Studio and Workout Matters.
Thank you, and thank you, Steve, for having me on your show.
So why don't you just tell us a little bit about how you started in the business and how you came to find out about PAGA, and of course, the group that you started, the nonprofit group you started.
Sure. Timely Industries is a pre-finished steel door frame manufacturer, and they've been in business since 1971. It's a family-owned business. I'm the president of the company. I'm not the owner. And we have approximately 200 employees, 52 immediate family members, 26 extended family members. So we do a lot of hiring within. We normally don't go through temp agencies. We don't go through applications and things. We just word of mouth, cousins and uncles and brothers and sisters come and work for our company. Average length of employment is 24 years, and we have employees that have been there as long as 37 years. So it's always been part of the company culture. Take the breaks together, take your lunch together, take working together as part of all the camaraderie. We've had a flexible work schedule at Timely. That flexible work schedule, we would have people come in, even in the manufacturing side, they could start as early as 5 in the morning, 5:30, 6, 6:30, 7, all the way up through 8:30. And the reason we did that was it was a way of trying to help our employees with a flexible work schedule. We have a lot of single parents. They want to get their kids off to school, or they want to be home when the kids do come home from school. They might have an event, they might have a doctor's appointment, they might have to take grandma or grandpa somewhere. So we've always allowed this flexible work schedule.
So essentially, you gave your employees extra autonomy. In other words, you were not a micromanager, more like a laissez-faire attitude, which I've always encouraged. We're not looking over your shoulder. We want to do what's right. We realize we might not necessarily be able to pay you considerably more than anybody else, but we can make your work environment as much as a second home as possible, right?
Absolutely.
Please continue.
Yeah, that's absolutely what we did. And, everybody's been eating their lunch, at 11 o'clock in the morning. We had a lunch truck. That same lunch truck had been coming to Timely for 25 years. And the lunch lady couldn't make it. She needed another 10 minutes. So lunches got moved to 11:10 because everyone said, hey, come on, we want to wait for the lunch truck. So I wouldn't have cared if they wanted to take their lunch at 9 in the morning, if they wanted to take it at 10 or 11. And talk about micromanaging, we wouldn't even force our employees to punch in or punch out for lunch. It was the honor system.
And then all of the sudden, something changed. What changed?
Well, what ended up happening is we had an employee that had worked for us, and she went out on a workers' compensation claim, and that workers' compensation claim wasn't most likely going the way that she thought it would be going. And then she was referred to a wage and hour attorney. And the wage and hour attorney said, hey, come into my office, show me your paycheck stub. What time do you get your break? What time do you take your lunches? I want to know all the details, everything. What is the safety incentive? How is it calculated? And before you knew it, we were served with papers. It's the Private Attorney General Act. And what the Private Attorney General Act does, it makes it very easy to certify a class. So it becomes a class action lawsuit. And the Private Attorney General Act, there's nobody to enforce the labor law. and the labor law digest is 1,060 pages. So if there's any violation from a California labor law, one person can become the Private Attorney General Act and enforce that. So this one person goes and, goes to the attorney, and then the attorney says, here's what's going to happen. We want to find out about your rounding up and rounding down method. We want to know what time you took your lunches. We want to know how you classified your safety incentives. We want to know if anybody worked past 10 hours. If you work past 10 hours in the state of California, you have to take a second lunch.
Okay, now hang on just a second there, because I want to ask Robert a question. He might know, he might not. Don't you need at least 25 employees before you can be certified as a class?
No, I think it's just up to the judge. It has to be numerosity. It's one of the factors.
Yeah.
For,
so you
for
can do it with
but
one
it's up to
and
the
one
court.
only?
No, then that's not numerosity, I would say.
Okay.
But numerosity is a factor. Whatever that means to the judge, that is beyond me.
Okay, Tom, please continue.
So, I'm sorry, hold on. Where was I at?
Well, that's okay. That's all right. You were talking about how you got from the attorney. The attorney called one of your employees in, asking about breaks.
Right, but
When the litigation kicked off. So
when the litigation. I was talking about the...
Yeah, you got referred from a workers' comp attorney to a PI attorney.
No,
I do that, right?
I was into the rounding up and the rounding down.
Okay, so rounding up and rounding down.
Okay.
Okay.
All right, so let's get back to that.
Yeah.
So they wanted to see these different violations, rounding up, rounding down, what time we took our lunches, what time we took our breaks, did we document these things? We had a safety incentive. How did we calculate that? Anybody that worked past 10 hours,
Second lunch, that's where we stop.
they
Second
have
lunch.
to have a second lunch. You can waive that second lunch, but you don't know how often you need to document it. If they get to 12 hours, you cannot waive that second lunch. If you work past 10 hours and you waive the second lunch, you have to provide the employee a third break. So there's a lot to keep track of. So when the attorneys ask for this information, it's a lot of data to get. I mean, we have 200 employees, so now we got to go check everything. We did not have employees that were punching in or punching out for lunch. And what we did is we decided to seek assistance from the state. We went to the state of California, the DIR, Department of Industrial Relations, and we said, will you please help us? We have written letters. We had almost 200 letters written from our employees, handwritten, a lot in Spanish, saying, please don't change our schedules. Please don't sue this company. I've been here most of my life. Family and friends are here. What can you do to help? So the state decided to take a look at our case. And when the state looked at our case, unfortunately, it still cost us over $1 million.
And I'm going to stop you right there. We've come up on our first musical break. We're going to come back to another news story or two and get back to Tom's PAGA case. You're listening to Work Comp Matters. We have special guest Tom Manzo of Timely, and he also started the nonprofit organization, the private for the PAGA, Private Attorney General Act, and that special organization is called
CABIA.
CABIA.
California Business and Industrial Alliance.
Thank you very much. I wasn't putting on my reading glasses at the time. My name is Steve Appel. You're listening to Work Comp Matters. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out, even front-row concert, sports, theater tickets, give Brian at Santa Monica Tickets a call, 395-8587. We'll be back after a short musical break.
How does it feel to be one of the beautiful people? Now that you know who you are, what do you want to be? And have you traveled very far? Far as the eye can see. Baby, you're a rich man. keep all your money in a big brown bag inside a zoo. What a thing to do. How does it feel to be one of the beautiful people? How often have you been there? Often enough to know. What did you see when you were there? Nothing that doesn't show. Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do.
Lachlan on Work Comp Matters. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system on the planet, used by more workers' compensation attorneys than any other computer management system, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out, even front-row concert, sports, or theater tickets, give Santa Monica Tickets a call. Tell our buddy Brian you said hello, 395-8587. My name is Steve Appel. You're listening to Work Comp Matters. We're talking to Tom Manzo about PAGA. When we left off last, actually, you know what? Should we do a news story? Or let's do a news story, and we'll get back to Tom. What can I say? He's my right-hand man. He keeps me in check and out of trouble at least 90% of the time with the second news story of the day, Mr. Mike Zyma.
Thank you, Steve. The United States Supreme Court said yesterday convicted California burglar James Garcia de Maya, who was ordered deported after he was convicted in 2 California home burglaries in 2007 and 2009, will for now stay in the United States because neither burglary involved violence. The Supremes also said the law requiring the deportation of immigrants convicted of certain crimes of violence is unconstitutionally vague. The court's ruling will not affect a number of serious crimes, including murder, rape, counterfeiting, or terrorism offenses, which are specifically listed in the law as grounds for deportation. Yesterday's 5-4 decision was pushed over the top by U.S. Supreme Court Justice Neil Gorsuch, who said, quote, "The American colonies in the 18th century cited vague English law like the crime of treason as among the reasons for the American Revolution. Also, today's vague laws may not be as invidious, but they can invite the exercise of arbitrary power all the same by leaving the people in the dark about what the law demands and allowing prosecutors and courts to make it up." And here's my favorite from Gorsuch. Vague laws invite arbitrary power. Isn't that eloquent? I like that. I happen to agree with this decision about the vagueness. What do you think, Robert?
Well, you're asking me whether or not on this specific case I would deport somebody who's convicted of 2 burglaries? Yes. really easily. Burglary is inherently dangerous, in my opinion.
Is it violent?
Yes, it's inherently dangerous. Not necessarily violent, but is inherently dangerous.
I believe the statute talks about violence.
Well, inherently dangerous and violence could be two different things, and if that's what the statute reads, they need to change the statute.
Well, it is vague then, is it not?
I don't know. I have to read the statute. But if it's inherently dangerous, put it this way. Someone breaks into your house, it's a burglary, you have a right to kill them, okay? So that is inherently dangerous. If you shoot somebody across the street because you missed the guy and you kill that person, the person who broke in your house is guilty of murder of that person. It's inherently dangerous. Any situation involving a burglary is inherently dangerous. To think that it's not enough to deport somebody. This is a felony.
Well, yeah,
all.
but the statute has to do with
It's not a misdemeanor.
Has to do with violent crimes. Now, let me ask you this.
Then they need to change the statute.
Of course they do. Well, that's what the court is saying. But let me ask you this. Do you think that, okay, on one of the burglaries, there was nobody home? Is that dispositive? Does that mean anything?
Well, I'm sure the burglar is the one who said that. I knew no one was home, right?
I don't know.
After the fact.
The lower court held that, though.
Yeah. If it's some sort of abandoned shack, maybe, right? I don't know the facts specific. I get it. But at least one, so you're referring to at least one that is not an abandoned dwelling that someone lives in, and this person was breaking and entering and committing a burglary, a felony, punishable by more than a year in prison, not jail, right? So if he gets shot dead right there, it's totally legal. I don't know. Doesn't it seem a bit much? Doesn't it seem beyond reasonable?
Well, the problem always was, I always had a problem with this statute because I thought it was vague at the outset. Okay, what type of violent felony is going to trigger deportation? And I think that's what the Supreme Court said, and I think they got that right.
Yeah, I could see that because what qualifies is going to be, an individual line that's drawn by every judge or every prosecutor. That does invite arbitrary decisions. But burglary seems to be something we should all be able to agree on. I think that's the issue here.
Mike and I were talking earlier, and Mike and I both agreed that the intent of Gorsuch's decision was that legislature, you have to go back and define what is violent and what is not.
It's not my job, legislature go and legislate. But the problem is, how many times do we have Dems and Reaps getting together on this stuff?
But this is also an issue of this person is already in this country illegally, right?
No. The person was in the country legally.
I do not think so.
If he was in the country legally, it's a different issue. If the person's in the country illegally already, and now it's a fight over the state versus federal, we're not going to give him up because, in our opinion, it's not dangerous, and the federal say, yes, it is, give him to us.
That's a good question, Steve.
I'm pretty sure that's how the dispute started, right? The feds say, give him to us, and they say, no, it's not dangerous. It's like, what are you talking about? This is a burglar. Give him.
I'm not sure he was in the country legally. He might have been here on a temporary visa, but I am not 100% positive.
Well, if he entered the country legally and then overstayed versus entering illegally, I get it, all right? There's a lot of issues. You got to know the facts of this one.
And I couldn't agree more. We've got special guest Tom Manzo. We're talking about PAGA, the Private Attorney General Act. When we last left off before the music break, you were talking, we had discussed what led up to the lawsuit. You went to the state, you asked them for help, and then I forgot what the response was.
It cost us $1 million. And you might say, well, what? How did you get $1 million?
Well, no, I'm not going to ask that. The first thing that I'm going to say is, did you go all the way to trial and a decision, or did you settle for $1 million?
No. None of these go to trial. Very few go to trial, and the ones that do lose,
so
and
you
it cost them a lot of money.
Can I ask a question, though, Steve? Did the state screw you over?
Oh, absolutely, without a doubt. No help whatsoever.
Did you retain an attorney?
Yes,
did you retain an attorney?
We did. No help.
And did the attorney tell you if you went to trial what your worst case scenario was that you'd have to pay out?
They tell you immediately, don't even go to trial on these. It's a lose-lose situation. So going back to the question, how did we get to $1 million? So they asked us all these different things, rounding up and rounding down, and they found out that we were clean on that. We were clear. The problem was the lunches were taken late. So if you take a lunch 1 second past 5 hours, then you owe that employee 1 hour's worth of pay. And then if you don't give that employee 1 hour's worth of pay, your paycheck's inaccurate. So if the paycheck's inaccurate, the very first paycheck is $100 penalty, and the next paycheck after that is $200. So the PAGA, which opens up the can of worms on the class action, is for 1 year. So they open up the can of worms on the class action with PAGA, and then they come in with the actual class action. So our case went back 4 years. So you're going back 4 years, 200 employees, late lunches, and a misclassified safety incentive. So this is a safety incentive we didn't have to give our employees. We didn't have to give it to them. We gave it to them just as a way of saying, hey guys, thank you. You were safe all year. We appreciate it. You know, go buy some extra goodies. You know, the total amount of that safety incentive was less than $700. So because it was miscalculated, we miscalculated the amount.
Did you say by 25 cents?
Less than 25 cents. Less than 25 cents. Because it should have been put into their overtime rate and then divided over the hours that they worked.
Now, do you know where the $1 million went? I mean, did you write one check to the attorney, or did you write 200 checks to each of the employees, or what?
Well, you know, it's really funny how a lot of these lawsuits work. And us going to the state, we really had felt, hey, you know what, this is a good company. It's a family-owned business. We have health insurance, full coverage, medical, 401k, matching 50 cents on the dollar. You know, I mean, very flexible work schedule. People wouldn't still be working for us if we weren't like that. And, you know, when we were with the state, the first question was, well, why do you have a flexible work schedule? And I said, hey, this is part of life, you know? And their attorney says, well, to me, it sounds like you're getting penalized. That's part of getting penalized as being a good employer. That's what the state told us.
So did you write one check for $1 million or 200 checks to 200 people?
Yeah.
Oh, well, this is the greatest part. So the state allowed us to give them $450,000 down immediately. They gave us another 90 days to pay the other $450,000. And if we were late, then they would charge us another $450,000 penalty.
And so when you say them, was it one check for $450,000, or did you write 200 checks?
No, they have a company that writes the checks.
Who is they?
The state or whoever would win the case, the attorneys. So they have.
So did you pay one check to the state of California? Or do you not know?
No, a certain amount is payable to PAGA, correct?
Right. Certain amount goes to PAGA. Certain amount goes.
Okay.
We had to pay the company that wrote the checks separately, and then don't forget you got to pay payroll taxes on all of that.
Of course.
Right. So okay.
Yeah, I completely understand. I know Mike wants to clarify something, and then we've got to take our second break.
I just want to clarify that some of the dough does not necessarily go to PAGA. Rather, it goes to the state agency that administers PAGA. That's my understanding.
Yeah, correct.
Which may or may not be the Department of Industrial Relations.
It's an offshoot, I believe.
Okay, very good. My name is Steve Appel. You're listening to Work Comp Matters. We've got special guest Tom Manzo of the California Business and Industry Alliance. We're talking about PAGA, the Private Attorney General Act. And as always, we're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120. For your no-strings money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out front row concert, sports, or theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. We'll be back after this.
Sliding on the upside of down. Let me tell you, baby, I have earned my craft. Lord, don't let me be misunderstood. Ain't got time to watch no grass grow or romancing with a Romeo. Here's the ticket to the rodeo. Lord, come on and love me like you could. Don't say I ain't a lady. I'm a single mother, got a family. Sometimes you need a piece of candy, a little bit of something good, a little bit of something good. See, I drive carpool and I do night school, social network. Oh, I got my arms around the world. Forget about your black book. Come on, baby, take a good look. Oh, the fish is jumping on the hook. Oh, don't think I wouldn't, 'cause I would. Don't say I ain't a lady. I'm a single mother, got my family. Sometimes you need a piece of candy, a little bit of something good, a little bit of something good. Something good, something good. Show me your good side. I ain't asking for no free ride. Come on over to my side, and you'll be feeling like you should. Oh, don't say I ain't no lady. I'm a single mother, got a family. Sometimes you need that piece of candy, a little bit of something good, oh, a little bit of something good, yeah, a little bit of something good.
Ooh, I love me some good sounds, some good folk rock sounds from Susan Scheller on Work Comp Matters. My name is Steve Appel. We've got special guest Tom Manzo of, we're talking about PAGA, and he is with the California Business and Industrial Alliance. Well, he's been with me since the start of Work Comp Matters. He's my protege, and with the third news story of the night, attorney Robert Ozeron.
Well, thanks for an introduction, boss. Starbucks announced on Twitter that 8,000 stores will be closing on May 29th. The Twitter feed reads, "Will close U.S. company stores owned to conduct racial bias training to address implicit bias and prevent discrimination. We're taking a hard look at who we are as a company. We're ashamed and recognize that racial bias is a problem we must address. We apologize to the two individuals and our customers for what took place at our Philadelphia store on Thursday."
And if you did not hear, last Thursday, two gentlemen of color walked in. They asked to use the bathroom. They were not going to purchase anything. They were refused the opportunity to use the bathroom, and I believe they would not leave. Therefore, Starbucks called the police. They were pulled out.
My understanding is they were waiting to meet someone before they ordered. But before they ordered, they asked to use the restroom.
Okay.
Said no.
And now, Tom, I want your opinion on this, because in my mind, this is a fantastic, a genius move by Starbucks. One of the first things you hear is, well, aren't they going to lose a lot of money by closing 8,000 stores for one day? But A, look at all the free advertising. B, look at this, what this is going to generate. And as a business owner, 200 employees, what do you think of what Starbucks is doing?
Well, I mean, I think they're trying to do what's right. There's absolutely no doubt about it.
Well, I've never seen any company in my entire life close all of their stores, and I mean even close to 8,000 on one day for any type of training whatsoever. Mike, Robert, have you?
No, but I don't know the facts of this one. It seems like most of the time, if somebody were to ask me to leave their store, I would have just left. In this case, I know there was some sort of encounter, and the guy called the cops. I don't know. I know that the Starbucks manager was thrown under the bus right away. That's for sure. I saw, what's his name, Schultz on MSNBC in the morning talking about his stock as it was going down because he's going to shut his stores down, right?
I'm sure the stock is going back up when the training comes into effect, which is going to be in May. I think you read the date. Now, here's my concern. Exactly what type of training and what are they going to do? Because from what I'm reading into this, from what I'm gleaning, this is not only going to be employees in class and getting training. I suspect that the employees are going to go through a lot of psychological testing because they're talking about to find out where their employees'
They'll probably
biases
do
are.
role playing and such.
Yeah, it wouldn't surprise me if all of their employees spend hours getting the old MP3 exam.
Isn't this a bit much for a barista? You know what I mean? Can't you just get a coffee and get out of there?
I'm sorry.
I mean, what is going on? It's not some social movement. I just want my cup of joe and move on, you know?
I didn't mean MP3. I meant DSM, the psychiatric
Diagnostic and Statistical Manual for.
Yeah.
MMPI and such.
And the MMPI and such.
Well, you know, so there was another bit of video that was shot by this African-American gentleman in a L.A. area store in January where he sat there and before he ordered, he asked to use the restroom and he was told no. And then a white guy 10 minutes later came up without ordering, asked to use the restroom and was allowed to do so.
Now,
so there's some problems.
Now, here's what I'm waiting for, and I want everybody at this table to remember I said this, and I hope I'm wrong. But let's say they, as part of the testing and whatnot, they give them psychological testing, and all of a sudden, out of 8,000 people, they fire 10% of them because according to their testing and according to that day, they have racial prejudices and bias that they didn't know about before, and therefore, they don't want them working for Starbucks, so they fire 800 people. Robert, what do you think?
I would suggest they call 310-999-9989 because that is going to be a workers' comp claim for your California employees there. Okay, that is not a good faith personnel action by any means.
What was that phone number again?
310-999-9989. But back to the easy plug for a workers' comp attorney to say that is not right to do. I don't know the point of this. I would have just, if I was Schultz, just said, you know what, we're going to take a hard look at this investigation. We'll let you guys know if there's issues that we have to correct. We're committed to correcting issues if they're there. But didn't he jump to a conclusion really fast that it was employees under the bus and close the stores? Like, very reactionary.
Now, here's part two. Let's say they do, and I know I'm harping on the psychological testing. Let's say some of these employees refuse to take the psychological testing.
There may not be testing.
Well,
it may be just instruction and role playing and kumbaya.
Which I think is a good idea. I like the idea.
Have you seen half the
kumbaya.
people who work at Starbucks? Oh, man. Good luck testing those people.
Well, I can't afford.
What's the matter with the people at Starbucks?
I can't afford to go to Starbucks on a regular coffee. I go to Ralph's and I buy a pound for like $5, and I've got my coffee for a month.
Don't you spend $5 for a cup of Joe? Don't you do that?
I spend $5 for a pound of Joe at my house.
Let's actually say, how many people actually have Starbucks here? I try to avoid that place. I think it's overpriced. It's only if you really want like a cup of coffee and you're out in the field.
I haven't been to a Starbucks in 2 months.
Do you go, Tom?
I have to be honest, I don't. It's a little expensive for me.
Yeah, that's what I'm saying. And
I can't remember the last time I went.
I like Don Francisco's.
Don Francisco's really good.
There you go.
There we go.
And Don Francisco's is $7 a pound, so I will spend the extra $2
I like the Costco
a pound, yes.
coffee myself. I think the Costco coffee's delicious. I go to bed at night dreaming to wake up to drink it. It's I think I might have an addiction, but that's a different story.
Indeed. We've got about 5 minutes left till the next break. When we were last talking to Tom, we were talking about where the money was spent, how you were cutting the checks. Go ahead, continue.
Well, in the process of doing all this, we reached out to the state for help. And we also reached out to a lot of the chambers of commerce, local trade organizations, politicians, assembly members, senators. And a lot of people weren't aware of it. They didn't know that much about it. Trade groups didn't seem to be too interested. The problem is a lot of these trade groups, they're more interested in naming the city Indigenous Day, instead of really working and helping out businesses. There's nobody out there to support the business.
I'm interested in making a Work Comp Matters Day. And see, what do I get? I get crickets. Okay, go ahead. Continue.
What about the California Manufacturers Association?
I reached out to them, and they were, my name's Tom Manzo, and they said, good luck, Tim.
Are you serious?
Yes, I'm 100% serious. And that's what drove me to say, you know what, I'm going to start my own trade organization. I got together with some other business owners, and I said, I'm fed up. Nobody's standing up to this. Nobody wants to change some of these labor laws. They're getting worse and worse as every year goes on. Somebody needs to raise their hand, draw a line in the sand, and say enough is enough.
And that's one of the reasons why I invited you on the show, because I want to talk to you about some specific labor laws. And let's talk about the first one, that when either an employee quits or an employee gets fired, the employer is required to pay them all the money that they owe them and all of the reimbursement for vacation pay if they quit within 3 days, if they get fired the same day. How far back do you think that the employer should have to go to reimburse the employee for payroll not paid? In my opinion, it should go back from day one. Do you disagree?
Yeah, I would have to disagree, because here's the thing. On our claim, the PAGA is 1 year, the class action is 3, so it was a total of 4 years. So we had a number of employees that no longer worked for us. Some of them we couldn't even find, and what ends up happening is, because the paycheck was wrong, say we were off 25 cents because of the safety incentive, we owe them 30 days worth of pay because we didn't give them the correct amount when they left.
Yeah, but that's a daily penalty for monies not paid. I'm talking about, like, let's say accrued vacation, or if they worked through a lunch and were not paid the overtime. You don't think they should get reimbursed that amount of money
from day one? What if they started 30 years ago?
Well, how come?
I mean, things change, laws change, times change.
Well, boss, I also think that if you're going to have to account for all of that, you might just straight bankrupt that company. I mean, think about that, right? You have to think about the actual
Well, I think administrative penalties are, in general, designed to put companies out of business that aren't compliant.
Well, not if you had a culture like that. The reason for a statute to go back a certain number of years, first of all, is one, knowledge of the employer, right? You can't expect them to keep records that long. And two, you don't want to try to account for all of these damages. You could actually bankrupt people. There's nothing to get.
Well, they're required to keep tax records for 7 years. So do you think they should go back 7 years?
But you were talking about up to 30 years now.
Well,
I was
just trying to find.
That'll kill a company.
I was only talking about payroll or vacation pay, which when you stop turns into payroll that's owed.
But here's the real issue, okay?
Okay.
So you talk to a lot of people, and I've talked to a lot of people. We formed our own nonprofit organization. So I'm hearing all the stories. I know more about PAGA than I ever wanted to know. But the real issue is, okay, it's supposed to protect good employees from bad employers. If I'm a bad employer and I get sued, I'm probably going out of business. It's going to have zero effect. If I'm a good employer and I get sued on a technicality. Okay, we're going to afford to pay it because we have to stay in business. So as far as I'm concerned, that's BS. And a lot of people just do not understand that. So a lot of the people that they're chasing after, you might have a contracting company. They employ 4 or 5 people, and they're not giving them the right paycheck. They're not paying them overtime. That kind of company, they're going out of business. A company like Timely, who's been established since 1971, 45 plus years, we're not going out of business. And companies have been getting hit. It's drastic. The amount is drastic. I went to the state and I said, I want a list. I want to know everybody that's been hit with a PAGA lawsuit since 2004. That's when this law was enacted. The state said it's going to cost you. I said, fine, I'll take the money out of my own pocket. You tell me how much it is. So the state comes back and says, well, it's going to be about $2,500, but we didn't start keeping track of anything until September of 2016. So there's a 12-year void on what's happened with PAGA and PAGA lawsuits. I get the list. There's over 8,000 companies that are being sued. And it's not just businesses. It's nonprofits. You're talking Salvation Army, Humane Society, Children's Home. The same scumbag attorney that sued Timely, what he ended up doing was suing a children's home that's been in business since 1938. They own a whole 2 houses here in the valley, and they have, I don't know, about 10 kids, and they're troubled youth between 13 and a half and 17 and a half. So who would sue somebody like that, and what judge would sit there and allow it?
Well, firstly, the rest of us at the table, I don't know that attorney, but we don't have the same opinion of him. That's your opinion, and that is fine. So getting back to my original question, I went from 30 years down to 7 years. So now can we go back 4 years?
4 years.
4 years, okay.
4 years.
So it's okay to go back 4 years, potentially a statute of limitations going retro benefits for 4 years. We've got more to come to on PAGA with our special guest, Tom Manzo. My name is Steve Appel. You're listening to Work Comp Matters. We're brought to you by A1 Law and Santa Monica Tickets. We'll be back after our last musical break.
Well, you can't turn him into a company man. You can't turn him into a whore. And the boys upstairs just don't understand anymore. Well, the top brass don't like him talking so much, and he won't play what they say to play. And he don't want to change what don't need to change. And there goes the last DJ who plays what he wants to play and says what he wants to say. Hey, hey, hey. And there goes your freedom of choice. There goes the last human voice. And there goes the last DJ. Well, some folks say they're gonna hang him so high, 'cause you just can't do what he did. There's some things you just can't put in the minds of those kids. As we celebrate mediocrity, all the boys upstairs wanna see how much you'll pay for what you used to get for free. And there goes the last DJ who plays what he wants to play and says what he wants to say. Hey, hey, hey. And there goes your freedom of choice. And there goes the last human voice. And there goes the last DJ. Down in Mexico, and sometimes it'll kinda come in, and I'll bust a move and remember how it was back then. And there goes the last DJ who plays what he wants to play and says what he wants to say. Hey, hey, hey. And there goes your freedom of choice. There goes the last human voice. And there goes the last DJ.
Tom Petty with The Last DJ on WorkCom Matters. My name is Steve Appel. You're listening to, or brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day. A1 Law. And if you want the front row, sold out, hard to get concert, sports, theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. I believe I have the last news story of the day. This is a workers, well, maybe I'll get two. One, a wonderful woman who I've admired for many years yesterday, Barbara Bush, died at home. She was 92 years old. She was surrounded by friends and family. For my workers' compensation colleagues and friends, there is a California Court of Appeal case which was denied writ of review by the California Supreme Court, which did take notice of Gomez v. Department of Corrections, 83 CCC 530. The case essentially holds that Saturdays and the days after holidays, such as Thanksgiving, Christmas, New Year's, any days after holidays that are Monday through Saturday, are business days. The Workers' Compensation Appeals Board, for purposes of timely utilization review, found the following to be factually true. And based on this, Robert, are you aware that most utilization reviews that had the first 5-day period over a Saturday or over a holiday are now probably untimely? Now, whether or not you can retro go back and get it, I don't know, but you probably want to take a look at this case, because 5 business days is now different than 5 business days before the case.
I think you were the one who were told me that when I was just starting out in workers' comp about
business versus calendar. And
well, just sending RFAs and when it must be approved by UR, things like that, and you have to count the weekends. We were always mindful of that.
Saturday's the big deal, calling that a business day.
I also think, for example, you have a holiday on Thanksgiving Thursday, so nobody works, but I think mail moves the following Friday. That is a business day. In addition, that is a business day. So a lot of those, what was the original URs that come over that period of time, that were originally timely are probably.
Isn't that a half day though? Don't things like the banks close at 12 on those days or something like that? Right?
At least for purposes of UR, there's no such thing as a half day, my boy. It's either a business day or a calendar day. It's either timely or it's untimely. We've got Tom Manzo. We're talking about PAGA. Tom, we've got about 13 minutes left, so pick it up where you left off.
Okay, good. The quick question, though, Steve, do I get a discount on those concert tickets if I want to order some?
Yes, and actually,
because I'm on the show?
No, yes, absolutely. And in fact, I'm going to tell you right now, Santa Monica Tickets, our buddy Brian, 310-395-8587. If you mention Work Comp Matters, you are going to get at least 10% off.
No, that sounds good. I'll take it.
Lakers, Clippers, Angels, Dodgers, anything and everything, something in Las Vegas, go for it.
Yeah. So getting back to our list of 8,000 companies, nonprofits have been sued in the last year on PAGA claims. And let's put it into real perspective. I ran an op-ed recently on Uber. So Uber drivers were misclassified. They weren't independent contractors. They were actually working for Uber. So there's this giant PAGA lawsuit.
Mike, myself, and Robert know a lot about Uber and Lyft drivers and independent contractors versus employees.
Right.
Please continue.
So this dragged on for a few years, and it sued. So this law that's so great and wonderful, so helpful to the employees, netted each employee $1.08 each. $1.08 each. Okay, so how much did the attorney get on this particular case? $2.6 million. Now, you talked earlier about who was writing the checks. How does that work? Who cuts the checks? Well, it's a different company that does that. They got paid $750,000 to write the checks. And how much did the state of California get on the Uber case? $3.6 million. So the driver gets $1.08, the attorney gets $2.5 million, and the state gets $3.5 million.
So the drivers would have been better off just doing it on their own.
Correct, but again, it's a trap law, and the attorneys that are going after businesses, they are no different than the ambulance chasing attorneys. It's the same thing. So they're allowed to come in and extort money from companies. They would have been better off if that attorney would have showed up at our place with a gun in his hand and said, "Write me a check for $1 million." It's the same thing, no difference.
Now, I know for a fact that Robert has a little bit different marketing style. I don't believe he's ever shown up at anybody's business with a gun. He prefers to show you
sport coat,
a sport coat tie, and
but it
and
looks
a picture,
flashy,
and a picture of an injured worker on a big van that's parked out by the curb. Right?
I mean, I think you have the right idea as far as a trade union and lobbying to get the laws changed, because the laws are what they are. I mean, I don't really fault people for playing by the rules. I would say you got to rewrite what the rules are if you don't like them. I looked into the other attorney. Looks like an impressive lawyer. I wouldn't want to go against him. That's for sure. But the purpose of the laws is difficult to look at the attorneys and say they're the ones profiting off of this. So the laws must be unjust, or the Salvation Army or another good sounding employer.
Goodwill Industries.
Listen, I have a case against Salvation Army. I'll tell you the truth. Half of the people in there are felons. Okay, the people working there. It's the truth. I had a PI case with a Salvation Army guy who worked there, who was a felon, beat up my client who was shopping there. So, listen, companies are made up of people. I understand that there may be a good intent behind the company, but after all, we're all just people. Okay. You got to change the laws if you don't like them. I would strongly support changing them to be more fair. We have to figure out what that is.
More fair and more reasonable.
I think you have a perspective and a strong perspective. Mm-hmm. I don't share that same perspective, but I do understand your concerns. I think looking at like an Uber case, that the individual driver gets $1. Firstly, I think 99.9% of them, that's $1 they got that they never would have gotten otherwise, because they would have never followed up. And second, the point is not for the drivers. It's to send a message to Uber that look at the penalty you must pay. You have to follow the law, right? And Uber, I think we could all generally agree that has been misclassifying people, skirting taxes for payroll and workers' comp. And there really is it's a fraud. It really is just a fraud that increases the rates on all the other consumers out here that we're paying for this, by the way, in a backhanded way. We really are. There's purposes of these laws.
Do you take Uber?
I do take Uber and Lyft.
Oh, okay.
I take Uber and Lyft.
You shouldn't, since you feel so strongly about them.
Well, no.
Don't take Uber or Lyft.
I feel strongly about the way they run their business.
Salvation Army either.
I don't buy Starbucks, but that's beside the point. And I don't go to Salvation Army because I don't want to get assaulted by one of their employees. And I'm not, defaming them or whatever, slandering them, because this is the truth. It's I have the actual fact that I know this happens. So.
And I wanted to say I sort of middle your position. I believe that prior to these laws coming into effect, a lot of employees were being mistreated and illegally being taken advantage of by their employers. I do agree that California clearly is the most litigious, costly company in America to operate a business. A lot of businesses have been taxed to death and have been leaving California to do business elsewhere, other states, other countries. So it's kind of gone overboard, but I think there has to be a happy medium. I know Mike wanted to give his input.
Robert, it just seems that it is damn near impossible to be in compliance with PAGA.
It seems like it's difficult, and maybe the pendulum has swung too far in that direction.
That's
I mean,
exactly what I meant to say.
We complain all the time of how far the pendulum has swung against workers' comp lien treatment, right, for providers. We can't find any medical treatment for our clients. And there'll be long-term employees, 20-plus years. You'll file your cumulative trauma no-fault claim after 2 decades of work, and what do you know? Denied. Okay? So employers, as nice as they are, they're not exactly... those in glass houses shouldn't throw the first stones, okay? I think that's somewhere from the Bible. And we do need to find a more fair system for both sides. And we can do studies, perhaps. We can have discussions. But we shouldn't be reactionary because we know the purpose prior to this was employees being ripped off left and right. So,
the real issue is simple. Who's running the state right now? It's the attorneys and it's the unions. And the unions make up 15% of the workforce. Half of that is state and federal workers. So why is the minority running the majority?
Your employees are not unionized, correct?
They're not unionized.
I have found that unions are actually not how they were back in the day where they would fight on behalf of the workers. Put it this way, every person I have that I represent who's part of a union, especially LA City and County, their unions have sold them out wholesale to the employer for probably some sort of backdoor kickback, no doubt about it, because you're part of these kangaroo ADR courts, okay, where you can't get a hearing day. It's awful. It is a full-on joke. Sometimes they call you to try to dissuade you from trying to file some sort of recon because only the board can straighten these ADR courts out. It's so bad. And I would say that when you say unions, I really think that insurance companies are the ones that are running everything. That's how I see it. I see the political lobbying on the insurance companies' efforts, and the small workers' comp attorneys like CABIA, all we're trying to do is find a way to get some treatment done or, get extra panels. That's we're focused on small things.
And, of course, who runs the insurance companies? But it's essentially those that are paying the premiums, which are the employers. And also, where does most of the lobbying money come from? One of the biggest employers in California paying the most amount of premiums and lobbying fees is Disney. We've come to the end of the show. It's been a great segment. I have learned a lot. I want to give many thanks to Mr. Tom Manzo of CABIA, the California
Business and Industrial
Alliance.
We need members. We need you to join.
Please give your phone number. Give your website, whatever.
The website is, and I'm old school, so I'm going to say www.cabia.org, CABIA.org, and call my cell number, 818-823-7611. Join. Be a part of the movement. Things got to change. You shouldn't pay $1 million because you were 2 minutes late for lunch. Sorry. Life doesn't work that way.
I don't think there's any reason to apologize, and that is not reasonable. I think
we're
we can all
looking for
agree
the fair.
on that.
We're looking for what's fair in this world.
Fair.
We try to make rules to make it fair, but we're just people. We try to write the best rules.
There's got to be a happy balance. For my right-hand man, keeping me in check and out of trouble 90% of the time, Mr. Mike Zyma. My protege, attorney Robert Ozeron. From Uncle Studio, engineer Scott Walton. My special guest, Tom Manzo. And, of course, back at Work Comp Central, all the good people that continue to support and approve of this project, including but not limited to Leaf File and Jake Paris. My name is Steve Appel. We'll see you again next week for another edition of Work Comp Matters.